Welcome to Medical Law and Ethics, Chapter 8, Privacy, Security, and Fraud. Over this chapter, we will cover the following learning outcomes. We will list the U.S. constitutional amendments and privacy laws that pertain to healthcare. We'll explain HIPAA's privacy rule. We'll identify those laws implemented to protect the security of healthcare information. We'll describe the federal laws that cover fraud and abuse within the healthcare business environment, and we'll summarize patient rights as defined by the Patient Protection and Affordable Care Act and state statutes. Here's a list of key terms that we will cover throughout this chapter. We'll start with privacy. Privacy is freedom from unauthorized intrusion. Contrary to popular belief, the term privacy does not appear in the U.S. Constitution or Bill of Rights. However, the right to privacy is derived from the amendments to the U.S. Constitution. The First Amendment, which is Congress cannot prohibit or abridge free speech, and the government cannot fund or show preference for or discriminate against any religion. The Third Amendment, soldiers cannot be quartered in private homes without consent of the owner. The Fourth Amendment, people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, no person must testify against himself or be tried twice for the same offense. This is the basis for the Miranda warning. The Ninth Amendment, if certain rights are not explicitly mentioned in the Constitution, that does not mean they do not exist. And the 14th Amendment, all states must provide rights for citizens that are at least equal to those in the U.S. Constitution. States may grant citizens additional rights not specifically granted in the U.S. Constitution. So once again, the rights to privacy are derived from the First, Third, Fourth, Fifth, Ninth, and 14th Amendments to the Constitution. The basis for privacy laws. Information that is collected and stored about individuals should be limited to what is necessary to carry out the functions of the business or government agency collecting the information. And then once it is collected, access to that personal information should be limited to those employees who must use the information in performing their jobs. Essentially, both of these are need to know. They only need to collect the information necessary, and you only need to access the personal information that you need to perform your job. Federal privacy laws. Personal information cannot be released outside of the organization without permission of the subject. So if you have not signed a consent or a release for your health records to be released to any person or organization, they are not allowed to do so. Also, if information is being collected about a person, that person should be made aware that the information is being collected and should have the opportunity to check the information for accuracy. There are a number of federal laws that concern privacy, but until the Health Insurance Portability and Accountability Act, or HIPAA, of '96, these federal privacy laws have dealt with financial and credit information or theft or illegal disclosure of this electronic information. HIPAA of '96 was the first federal law to deal explicitly with the privacy of medical records and ensure compliance. HIPAA also provides for civil and criminal sanctions or charges for violators of the law. A definition of HIPAA, or the Health Insurance Portability and Accountability Act, is a federal law passed in '96 to protect privacy and other healthcare rights for patients. The Act helps workers keep continuous health insurance coverage for themselves and their dependents when they change jobs, protects confidential medical information from unauthorized disclosure or use, and helps curb the rising cost of fraud and abuse. Because HIPAA is a federal legal standard for privacy and security of health information, employees must follow the law's provisions, which are contained within 4 standards. Standard 1, transactions and code sets. So transaction refers to the transmission of information between 2 parties. It's used for financial or administrative activities, and a code is a set of codes used to encode the information to make it easier for accurate diagnostics, but more difficult for the average person to read. They're referred to as diagnostic codes or procedural codes. We're currently on ICD-10 codes, or the International Classification of Diseases 10th edition. Standard number 2, the privacy rule. Both healthcare providers and their business associates must put in place policies and procedures to ensure confidentiality of written, electronic, and oral PHI or protected health information. We'll expand upon this more in a moment, but this is just a quick definition. Standard number 3, the security rule. Security refers to those policies and procedures that they're using to protect electronically transmitted and stored PHI from unauthorized access. How are they keeping it safe? What those policies are. And standard number 4, national identifier standards. In this, they'll provide unique identifiers for electronic transmissions. So once again, Standard 1, transaction code sets. Standard 2, the privacy rule. Standard 3, security rule. And Standard 4, national identifier standards. To expand upon HIPAA Standard 2, privacy, protected health information, or PHI, must be protected against unauthorized disclosure, whether it is spoken, written, or in electronic form. So if you're having a conversation, it needs to be with someone who needs to know. It needs to be in an area that you won't be overheard, and you can't have names or identifiers where people could understand who you're talking about. Sometimes these identifiers are simple things that you wouldn't even think about. You could refer to a patient as the one that has purple hair. Well, if a family member is walking past and they know their patient or their family has purple hair, they are likely to believe you are talking about their family member. In written form, you need to be careful not to have files or other information laid out where people can see it. If you're working at a desk, make sure things are turned over if you're not actively using them. And in electronic form, you need to be sure you're sending to the correct addresses. And if you're printing on a printer or anything else, be sure that you are there to get those sensitive files immediately when they print. So patient identifiers can be all sorts of things, from name, address, social security number, zip codes, email addresses, medical record numbers, driver's license, photos, and many other items. The things used to identify a patient can vary depending upon the situation. Protected health information includes past, present, or future physical or mental health conditions, documentation of the provision of health care, and past, present, or future payments for the provision of health care. If PHI is to be used for research or other studies, it must be de-identified or have all patient identifiers removed from it before the data is transmitted. Healthcare providers and plans can use and disclose patient information, but to do so legally, they must identify a permission. HIPAA legislation identifies only 6 defined permission. The first of these is disclosures to patients. HIPAA does not only permit, it requires that PHI be disclosed to any patient who asks to see his or her own medical records. This can include talking to the patient about their diagnosis, treatment, or medical condition, as well as allowing them to review their own medical record. Some psychotherapy notes may be withheld due to potential harm to the patient, or the doctrine of professional discretion. Use or disclosure for treatment, payment, or healthcare operations. So inside of a healthcare facility, both the provider and other employees would need access to PHI in order to coordinate care, consultations, discussing a patient's condition, prescribing medication, ordering tests, surgery, or other reasons pertaining to their care. If outside covered entities, such as insurance plans or employers, ask for access to the PHI, you must have the patient's written permission, but they may receive that information once that's obtained. Use and disclosure with the opportunity to agree or object. So this is an informal permission that clearly allows individuals to agree or object. So you're visiting your doctor's office and the doctor wants to look you over. You are granting him that permission to view your PHI in order to treat you correctly. This can be a verbal agreement. You can comply silently or without objection, or you could object to it and probably be unable to be seen. In emergency situations, physicians and other healthcare practitioners can make a professional judgment to use or disclose as it's determined to be in the best interest of the individual patient. Incidental uses and disclosures. So, incidental use is permitted without authorization from the patient as long as reasonable caution is taken to prevent unauthorized individuals from overhearing. This could be staff members talking about a patient's care, practitioners talking to a patient on the phone, or discussing treatments with other providers on the phone. Healthcare practitioners discussing lab results, either with the patient or amongst themselves. Healthcare practitioners can leave messages on answering machines or with family members, but the information should be limited to the amount necessary. Normally, they would just ask for the patient to return the call. You can still ask patients to sign in or call them by name in a waiting room, but you must not ask for the reason of the visit. So essentially, you need to be always cautious of who can overhear your conversation. You want to be sure that you are not discussing a patient in a way that others could identify them and their situation. Making sure that there aren't visitors, etc., nearby while you're discussing patient care. Public interest and benefit activities. So PHI can be released without written authorization for 12 national priority purposes. These are, if it's required by law, as part of a public health activity, for victims of abuse, neglect, or domestic violence, in health oversight activities, for judicial and administrative proceedings, for law enforcement purposes, for descendants when cause of death is released to a funeral home, coroners, or medical examiners, for cadaver, organ, eye, or tissue donation, for research, in the event of a serious threat to health or safety, for essential government functions, or in claims for workers' compensation. And lastly, a limited data set. So when health research is going on, or healthcare operations, public safety, a limited data set can be released. This is PHI, from which certain specified direct identifiers of either the individual, their relatives, household members, and/or employers have been removed. The recipient of this limited data set enters into an agreement promising specified safeguards for the PHI. PHI usually consists of either an electronic medical record, an EMR, or an electronic health record, an EHR. An electronic medical record contains information from just one provider or facility, whereas an electronic health record is a comprehensive record focused on the total health of that patient. It usually contains information from many providers or facilities and is more of a data set from birth till death of that patient. HIPAA security rule. So HIPAA security rule is HIPAA standard number 3, and it establishes a national set of security standards for protecting certain health information that is either stored or transmitted in electronic form. Essentially, the security rule is the operational portion of the protection set forth in the privacy rule. The security rule identifies the technical and non-technical safeguards that they must have in place to secure PHI. And there are substantial fines if found to be in non-compliance with this security rule. The high-tech rule. The Health Information Technology for Economic and Clinical Health Act, or high-tech rule, strengthened HIPAA protections by extending compliance with the rules to their business associates, prohibiting sale of information without permission, expanding individual rights to electronically access PHI, things like a patient portal, prohibiting the use of genetic information for insurance purposes, finalizing breach notification requirements, expanding individual rights to restrict access to certain information, limiting use and disclosure of PHI for marketing and fundraising, improving access for schools to immunization records, this would be like ImmuTrack, and removing the privacy rule from individuals deceased for more than 50 years. Breach notification. So a breach is an impermissible use or disclosure of a patient's record by a covered entity. The true definition of breach is any unauthorized acquisition, access, use, or disclosure of personal health information that compromises the security or privacy of such information. Sometimes these breaches are done by hackers, sometimes it is failure on the part of the employees of the company. But any breach of more than 500 records requires notification of the media in addition to notifying the patients affected by the breach. This allows the public to learn of the problem early on. Also inside of the High-Tech Act, business associates must also follow notification guidelines set up for healthcare providers, and the fines for breaches may be substantial. In 2018, a single judgment was for $28.7 million. Fraud and abuse in healthcare include both federally funded programs like Medicare and Medicaid, private insurance, and self-pay patients. Opportunity for fraud is great, and it's almost impossible to accurately pinpoint the true cost of fraud in healthcare programs, but estimates reach approximately $1.2 trillion a year is wasted or abused in healthcare. Fraud and abuse will continue to be a problem because they're difficult to detect. It's not easy to separate fraudulent spending from the total healthcare dollars spent. Fraud continues to increase, and healthcare fraud schemes are often regional and viral. Criminals will copy fraud techniques that others have been successful with in their communities. And fraud often goes undetected for months or sometimes even years. The Office of the Inspector General is a nationwide network of auditors, investigators, and evaluators. They are responsible for more than 300 federal health care programs and oversee the enforcement of the Federal False Claims Act, the Federal Anti-Kickback Law, the Stark Law, and the Criminal Health Care Fraud Statute. The Federal False Claims Act is a law that allows for individuals to bring civil actions on behalf of the U.S. government for false claims made to the federal government under a provision of the law called qui tam, from the Latin meaning to bring an action for the king and for oneself. These are commonly referred to as whistleblowers, and if you are the person that brings the attention to these problems, you can share a portion in the court-awarded damages. Things that fall under the False Claims Act are making a false record or statement to get a false claim paid by the government, conspiring to have a false claim paid by the government, withholding government property with the intent to defraud or willfully conceal it from the government, making or delivering a receipt for government property that is false, buying government property from someone who's not authorized to sell it, making a false statement to avoid or deceive an obligation to pay money or property to the government, or causing someone else to submit a false claim by giving false information. But just to reiterate, the major point for the Federal False Claims Act is whistleblowers may share in any court-awarded damages. Starting in 1972, the Federal Anti-Kickback Law prohibits knowingly and willfully receiving or paying anything of value to influence the referral of federal health care program business. Violators of the law can receive punishment in the forms of fines, prison terms, or the loss of participation in those federal programs. The Stark Law prohibits physicians or their family members who own healthcare facilities from referring patients to those entities if the federal government under Medicare or Medicaid will pay for the treatment. So essentially, physicians and healthcare providers cannot refer patients to a business they have a vested interest in, either owned by a family member, themselves. So if I'm the physician and my patient needs x-rays, I can't refer them to the radiology facility down the road that's owned by my brother-in-law. And this applies only to Medicare and Medicaid program participants, but in a general sense, it's poor business practice to refer people to a vested interest of yourself. Generally, 3 questions determine whether or not a request for reimbursement is prohibited by the Stark Law. Has a physician or a member of the physician's family referred a Medicare or Medicaid patient to an entity? Is the referral for a designated health service? And is there a financial relationship between the referring physician or family member and the entity providing service? If any of these 3 questions is answered yes, the referral violates the Stark Law. The Criminal Healthcare Fraud Statute prohibits knowingly or willingly executing a scheme or attempting to execute a scheme with the intent to defraud any healthcare program, or with the intent to obtain, by false pretenses, representations, or promises, any money or property under the control of any healthcare benefit program. Proof of actual knowledge or specific intent to violate the law is not required. Penalties for violating the Criminal Healthcare Fraud Statute include fines, imprisonment, or both. Thank you for joining me for Medical Law and Ethics, Chapter 8, Privacy, Security, and Fraud.